name is Jane Armstrong. I'm a resident of Venice and a member of the VICA board. We have a speaker tonight. The topic she's going to talk on is environmental racism. Jeanne Zokovitch Paben is a Sarasota resident, attorney-in-law. She's a graduate of the University of Florida. She went to law school to study environmental law in Vermont, and after that she went to, she got her Juris Doctorate from the University of California, Hastings College of Law. She's going to speak about several issues, but the one that brought her to my attention was a case that she took defending the community of Tallavast, which you may know on the borderland of Sarasota and Manatee County. She was able to represent that community successfully and secure a $3 million settlement for them because of an environmental impact that negatively affected their land and water. So I would like you to welcome now to the podium, Jeanne Paben.
Thank you, Jeanne, and I just want to say thank you to the Venice Interfaith Community Association for having me this evening, and also for this series that they're doing on racism and how it infiltrates different parts of our lives. As Jeanne indicated to you, I was asked specifically to speak about how racism plays out in the context of environmental issues. And so what you're going to hear from me mostly tonight is about environmental justice, which is the goal of addressing environmental racism, and we'll talk about that throughout. Just so you know, a little bit on my background is that in addition to practicing law for 12 years on environmental issues in Florida, I also was a law professor for 11 years in Florida, in North Carolina, and Colorado. So you will see that my presentation, I'm sure, kind of seems a little bit like a law professor or political science professor. I know that there are people here with varied interests along this topic, as well as different levels of backgrounds. So I've tried to start the presentation with a lot of the facts and figures, history that gives you the concept of what is environmental justice, how did it come about, how has it played out. What I hope is that I can actually move fairly quickly through a lot of the academics and get you to the later part of the presentation, where I'm going to give you a brief glimpse at 4 environmental justice communities that I worked with during my practice in Florida. And one of these, as Jane indicated, is Tallavast, which is on the border of Sarasota and Manatee County, so very close to home. And then I'd like to end the presentation just by giving you some sense of where we are, what we can do, how do you know environmental justice issues when you see them, and hopefully for those of you that are interested in getting more involved, this will give you some sense of those things. I will tell you that this hasn't been an issue that has gotten the legal and political support that it needs, and so I do tend to be a little depressing at times, but it's more about the facts than I think it is my demeanor. I will do my best to show you the positives in it as well as the negatives. Right. This worked before, Jason. I'm so sick. Just pointed at that little thing hanging down back there. We did test it. There it goes. All right. So environmental justice is an aspect of environmental law. So just real quickly, I want to kind of remind you of the history of the environmental movement and environmental law in the United States. So this slide tells you that in the late 1800s is when we first start thinking about the birth of the environmental movement. And at that time, there was tensions between kind of both preservationists and conservationists, but together they all agreed that there was this benefit to wilderness areas and outdoor spaces. And you would, have quotes about how men needed to take themselves into the rugged terrain, right, in order to refuel and refocus. And that a lot of these episodes for great leaders brought about a lot of the great democratic decisions that were made. Probably most notable would be Teddy Roosevelt, right, who was instrumental in the birth of the environmental movement. In the 1800s, with that tension between preservation, kind of leaving the land undisturbed, and conservation, which was finding that middle ground of trying to leave land undisturbed, but also to utilize the land, you had the birth of the National Park Service, the Forest Service, the dedication of some of the national parks that are mentioned here as well. Over time, though, the environmental movement moved, even though my clicker's not. We really did test this, right, Jason?
Yeah. Okay, try it again.
Oh, no, I wanted to do it too fast. So here's our preservation conservation, right? And then we move on to kind of the 1960s, where there start to be a sparse set of common law precedents and local ordinances. So local ordinances obviously are law made by local government. Common law is what we call case-made law. This is law fashioned by the courts about particular controversies, right? A particular dispute. But common law also has precedent, which means once it's kind of established as a general principle, that principle guides similar cases as they come forward. So we have laws starting to be fashioned to address environmental issues in the 1960s that looked at it through these common law and local ordinance perspectives. The Ducktown case is a famous case about copper mining on the Tennessee-Georgia border, and it showed some of the early advent of the implications of these laws. Around the same time, you see here St. Louis winning the fight on smoke. In our urban areas, we were seeing a lot of issues associated with air pollution as we were becoming more industrialized, and so this also brought about local ordinances in the advent of common law. So it became kind of clear that we needed more than what we have historically had, and so invoked the modern environmental movement or the regulatory movement. As most people know, in the 1970s and early 1980s, most major federal environmental statutes were passed. We like to call environmental law alphabet soup, and you can probably tell why from all the acronyms up here. We came up with acronyms because we realized if we had to say the name of all the environmental laws, it would take too much time. But some of these laws, the National Environmental Policy Act, the Endangered Species Act, the Clean Water Act, the Clean Air Act, RCRA, the Resource Conservation and Recovery Act, NIFMA, the National Forest Management Act, and CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, were all brought about during this regulatory meeting. So all of these focused on different aspects of environmental law, and their name kind of tells you what area. But they started creating a federal regulatory scheme to address key pollution issues that otherwise, as I said, were being dealt with by local governments and to some degree through the court system. The 1980s actually just continued kind of a refining. We still had some of these environmental laws being passed in the early 80s, but we also had kind of add-ons, retooling of some of the early statutes. But then we come to the 1990s or the 2000s. There's kind of a backlash from the regulatory structure. We want to go back to the days of preservation and conservation, but we have all of this regulatory structure now that we have to kind of work within. And so it shifts a little bit towards kind of free market ideas and this concept of cooperative conservation, right? Which is how do we have private parties to engage and find win-win solutions in dealing with environmental issues. And around this time, environmental justice also starts to become a more prevalently known issue. It's hard to put it on the timeline because really some of the early advent of environmental justice cases start presenting themselves in these community battles in the 70s and into the 80s. But in actuality, kind of everyday person's understanding that there is even such a thing as environmental justice really didn't occur until the early 2000s. We're still going to talk about its history specifically. But really, for most people to understand that environmental justice is even an issue doesn't happen until the 2000s. So just briefly, I won't go through all this slide, but this is the history of environmental law. All it does is categorize some of what I was telling you, right, in time frame. Pre-1945, this is the law that we relied on to address environmental issues. Between 45 and 62, we see the feds mostly putting it on state and local governments. 62 and 70 is when we get the rise of the environmental movement. The rest of it continues with what we were just discussing. So, environmental law history in a nutshell is what this slide is about, and it just kind of distills down what we were talking about, which is that environmental law originated with common law, that case-made law that we talked about. We still have common law that addresses environmental issues because where there is no statutory regulatory framework, we rely on common law to address those issues. There's actually been an interesting dichotomy in recent years between the interplay with common law and statutory law as it relates to climate change. Since that's not the primary focus of my discussion today, I'm not going to touch much on it, but we'll get glimpses of that as we move forward. What the next part of this slide tells you, though, is agencies, right? So when I'm teaching law, I start by explaining to students that the source of law can come in many different forms, right? The Constitution at the top, then we have statutes at the federal or state level, then underneath that, you may go straight into case law, which can be cases, not common law, but cases interpreting the Constitution or the statutory law. You also have that common law sitting out there about issues not addressed in the regulatory system, but then you have rules and regulations promulgated by agencies, which usually give specificity to the statutes that the state and federal government have carried out. And sometimes you have case law interpreting that stuff, because that's how lawyers get paid. What you see, though, is that there is a great overlap in environmental law in some of these different areas. And so depending on the problem that you're addressing, you could find yourself wading through any of these different things. One of the other challenges, though, is that law, having evolved over time, is done on a piecemeal basis. We've already talked about the fact that case law is about this dispute between these two parties. And so in that case, we fashioned this rule and then later found that that law was relevant to other disputes. But we find in the next case that we haven't got the full answer because there's new facts now that we have to deal with. So you see that piecemeal approach when it's common law. But this is also true with the statutory and regulatory framework as well. Because rarely does the legislature write a law and leave it alone. They write a law, they repeal the law, they put it back in, they change some words which seem insignificant until the lawyers get paid. So you see this constant evolution. You create an agency to address certain things, and then you find other problems that no one's addressing. You say, oh, that kind of sounds like their work, and so then you pass more statutes and give them to those agencies. So now the agencies are working on all of these different things. So it is important to remember that this organic piecemeal nature of how the legal backdrop is created does create additional challenges in addressing these issues. So how or where does environmental justice fit with all of this? Well, first let's start by defining environmental justice. The general concept of environmental justice is that living in an industrialized society brings both environmental benefits and environmental burdens. And the nature of environmental justice is that the burdens are disproportionately thrust upon certain populations, thereby creating injustice, right? So EPA and the federal government coined the term environmental justice, but in actuality, environmental justice is the goal. It's not the actual thing we're dealing with. What we're dealing with is environmental injustice. So what does the goal look like? Well, according to EPA and their definition, it's the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. This is the EPA standard definition for environmental justice. It has been since its advent of the definition of environmental justice. As you can see, it's a very lofty goal. It's essentially saying there is no discrimination in the way our laws are created or enforced, right? That's the goal, remember, as I see the chuckles in the audience. Okay. So, getting back to the problem, it was coined today as environmental racism, and that's not an inappropriate term by any see that studies show that race is the most dominant factor in finding this disproportionate impact. It's not the only factor, but it is the most dominant factor. So you will also see the same phenomenon that I'm talking about tonight called environmental racism. You'll also see it called environmental injustice, as we talked about, because this is what's actually occurring. That's why we have a goal of environmental justice. Sometimes, depending on the context, this is one of those things, careful what you wish for. People say, how do you know an environmental justice community when you see it? Do you have to count up the statistics from the Census Bureau to determine how many people are of color or how many people are below a certain income to coin it an environmental justice community? And I'm sure there are certain aspects of life where that actually takes place. But with law, there is no environmental justice law. That's what you're going to find out. And so there is no requirement to do that type of demographic research just to say, aha, we found it, now we can help it, right? So in working parlance for people who are working on environmental justice issues, if I'm getting grants from private foundations that tell me to work on environmental justice, do I have to count up these facts and figures in order to document that this community is worth helping? I'm absolutely sure that there are people out there that probably require that. For me, for the 8 years that I worked with environmental nonprofits, and then when I ran a legal clinic, I didn't have such burden. I knew environmental injustice when I saw it because the population that had the burden disproportionately thrust upon them were not the decision makers. The people living with the problem were not the people deciding they should live with the problem. And so that was always my first hint that there was some environmental injustice going on. And lo and behold, when I would go to the communities, guess what they looked like? They were predominantly of color communities, and oftentimes where race was not necessarily dominant, there was absolutely low socioeconomic communities. Now that being said, these communities were rarely completely homogenous of a certain color or of a certain socioeconomic level. In historic ethnic and racial communities, particularly in places like the South, where it was heavily segregated for years, when you rose up the socioeconomic ladder, you didn't move to the fancy neighborhood. Early because you weren't allowed to, right? But as it later went on, you had developed such a strong sense of community and sense of place that you stayed where you were. And so if you look at Tallavast, although it's changed a lot in the almost 20 years that I've been working with them, you would find very mixed socioeconomic in these of color and ethnic communities because they had a strong sense of place and community. And even though they may have had more money, all they did was build a bigger house because they still wanted to be near their cousins, their brothers, their uncles, their church. And so these strong senses of places kept you there regardless of your socioeconomic status. So the historical background, this is called making the case for environmental justice, when environmental injustice starts getting attention nationally in the United States. Starts with a case actually in North Carolina. A lot of people know about this case. This is in Warren County. There were protests surrounding the siting of a PCB landfill in an African American community. There were pictures on the TV where you had both citizens and politicians, including national politicians, coming and laying themselves down in front of the trucks, bringing this hazardous waste into this community where it had not been developed, but where it was to be disposed. And so much of the early attention on environmental injustice is in this context, where we have landfills, predominantly hazardous waste landfills, and we're seeing that regardless of the fact that the waste isn't generated in communities, it's being brought to these communities, typically of color communities, and often low socioeconomics. So the federal government interest propels the federal government to get involved. And the United States General Accounting Office does its own report. It's called The Siting of Hazardous Waste Landfills and Their Correlation with Racial and Economic Status of Surrounding Communities, which was released in 1983. And it documents exactly what I told you is the concept of environmental justice, that environmental burdens of living in an industrialized society are disproportionately borne by people of color and low-income communities in the United States. Around the same time, others are getting involved, predominantly the United Church of Christ. The United Church of Christ issues a report in 1987 from their Commission for Racial Justice, which is the national report on the racial and socioeconomic characteristics of communities with hazardous waste. government involvement in the 1990s. The United States EPA creates the Environmental Equity Work Group, and they do a report in 1992 that is called Reducing Risk for All Communities. And in that report, they again document disparity, this time in the enforcement of environmental law in these same communities. So not just the citing of hazardous waste, but how people are actually protected under the law. The National Law Journal also documents this in Unequal Protection, the Racial Divide in Environmental Law in 1992. They look specifically at Superfund. That's what we like to call CERCLA, because you guys saw how much fun that whole name was. Superfund is a pot of money that was created under CERCLA in recognizing that we were having large quantities of heavily contaminated property throughout the United States that were not getting addressed. And the perception was that both they presented hazards because of the contamination, but that they also thwarted redevelopment of what could be viable land. And so the concept was that we needed to do something about these sites. So CERCLA came into play. It gave a super fund, which was funded by what's called the polluter pays tax, meaning industries that typically contribute to pollution gave money to the fund for the federal government to use to clean up these sites. And so the National Law Journal looked at the cleanups of Superfund sites and found that when the community was white or more affluent, that it took less time for them to get their site cleaned up, and the standards at which their sites were cleaned up were better. There were also a number of studies looking at the toxic release inventory sites. It's always interesting when I have students who come in and think they're interested in environmental law, and then they realize how jargony and book heavy it is, and that they get pasty white looking at administrative records instead of climbing trees. But the toxic release inventory comes from a little known environmental law called EPCRA. EPCRA is the Emergency Planning and Community Right to Know Act, right? It does not sound like an environmental law at all. But what EPCRA did was say, we should probably tell people about all of these contaminants out there in society. And so we started making industry documents when they were working with hazardous materials. And they documented any releases of those hazardous materials, right? Toxic release inventory. And this still exists today, although its availability of information has changed over time. But this was a bigger deal because historically we were talking about landfills. We were talking about some of the really big bad sites that everybody knew something bad was happening there. But all of a sudden the toxic release inventory showed people that there were thousands and thousands and thousands of sites handling hazardous materials and releasing toxins into your air, water, or land. And they were nearby. And that's what the toxic release inventory showed us. Several of the studies, including one that I like to highlight in 1997, actually out of Florida State, although I'm a Gator, by a man named Evan Rehnquist, showed that toxic release inventory sites were disproportionately located in communities of color and low-income communities, and that the amount of releases were also greater in those communities. And as I said, there were a number of reports that showed this correlation, not just to landfills and big Superfund sites, but to toxic releases across the board. So this seems to be enough to bring in a government response. And so we do see some government response during the Clinton administration. So what kind of outcomes do we see from US EPA? In 1993, EPA does a number of programmatic changes. First, it creates something called NEJAC, the National Environmental Justice Advisory Council, which is made up of academics, scientists, community residents, government people, all supposedly dialoguing to address environmental justice issues. And this is first founded in 1993. For the first time, EPA also establishes an Office of Environmental Justice, acknowledging it as a phenomenon that needs to be addressed. And they also create an environmental justice grievance process under Title VI of the Civil Rights Act. But probably what's gotten most attention is in 1994, President Clinton uses his executive order powers and issues Executive Order 12898. And this is known as the Executive Order on Environmental Justice. justice movement. So these were the basics. A citizen complains to the EPA's Office of Civil Rights, and that office is supposed to acknowledge that they've received the complaint within 5 days. Within 20 days, they can accept the complaint, they can reject the complaint, or they can refer it to an appropriate federal agency. If it's accepted, within 180 days of receiving the complaint, they have to tell the people who complained and the recipient agency what they found in their investigation regarding whether or not there are environmental justice issues, and make recommendations for voluntary compliance, meaning telling the agency what they've done wrong and asking them what they can do to bring themselves into compliance. This is the Title VI grievance process. This is what is required in the rules that EPA promulgated in creating this process. So, in addition to the federal government response, we also saw attorneys in the field using a variety of legal tools to try to address environmental issues. And there was some early success, as I said, in the 80s predominantly. So first they used some provisions under the US Constitution, the Due Process Clause and the Equal Protection Clause. They used aspects of Title VI of the Civil Rights Act, Section 601 and 602, and then Section 1983 of the Civil Rights Act as well. I'm going to talk about each of these briefly. The Fifth Amendment, right, to the Constitution says no person shall be, and it has a couple of other things that are not relevant to this, but then it says, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So there isn't actually a federal Equal Protection Act. It's the Due Process Clause in the Fifth Amendment that is read as requiring the federal government to treat people equally within the law. Specifically, the Fifth Amendment actually has two clauses that are relevant to environmental justice. The first is that Due Process Clause, right, which says we can't take your life, your liberty, or your property without due process. And due process has both a procedural and a substantive component to it. It means without doing certain things, providing you notice, giving you an opportunity to complain, talking about alternatives, etc., etc. But it also has a substantive aspect, and that's the aspect that people think about as being equal right to equal protection. Because I can't utilize my power against one people and then turn around and say it's unnecessary in the context of a similar situation. The Takings Clause, which lots of people are familiar with, essentially says, but remember, I can take it away if I really, really need it, and I can prove it's for a good public use, as long as I reasonably compensate you. So that also has some play in the environmental justice context. Now, although there's no direct equal protection clause for the federal government, there is for the states, and that's the 14th Amendment. And the underlying thing here tells you that no state can deny to any person within its jurisdiction the equal protection of the laws. It's just flat out stated. Title VI has a section 601 and a 602. 601 always starts as like, what's the purpose of the law? The purpose is to prohibit discrimination. And it attaches to any entity or program that receives federal funds. And then 602 says to federal agencies, and we'd like you to make your own agency rules about how you're administering your programs to be sure that you're not causing environmental injustice. And so the agencies then get to pass rules that show how they're contributing to this. So early on, we saw some success predominantly under 602. So one thing to note is that both the Equal Protection Clause and 601 have always been held to require a showing of discriminatory intent, which is a really high bar. We'll talk more about this. Section 1983 is another provision in the Civil Rights Act, but it specifically provides for an individual's right to sue based on a deprivation of their civil rights. It's important to know that the definition of the terms, many of which I have highlighted, are incredibly convoluted as defined by the court. So it says every person, but it really only applies to certain people. And so the question is, in the decade that follows, how did environmental justice fare? So in 2004 and 2005, two different federal government agencies, the Office of the Inspector General and the General Accounting Office again, do reports looking at EPA's implementation of Clinton's executive order. And I'm not going to read the whole quotes, but they essentially say they haven't done very well, right? They've not fully implemented nor consistently integrated environmental justice as the executive order intended. The GAO report essentially says they punted and passed the buck on to state and local governments to address these issues. And one thing I'd like to highlight here is that they say, even though the executive order does not apply to state or local governments, and absent specific state or local law, they have no obligation to consider environmental justice. So we are held by law at the federal level to make sure that we're considering it, but we're going to pass it on to someone else who has no enforceability or requirement to actually address these given issues. This is why I call it punting. Similarly, we see reports on the Title VI grievance process. In 2011, there's an evaluation of the EPA Office of Civil Rights done by a consulting firm contracted by the Environmental Protection Agency. It says the Office of Civil Rights Title VI track record is inadequate, unresponsive to EJ communities, and in some cases damaging to EPA's reputation. This is the depressing part, right? Only 6% of the 247 Title VI complaints ever received by OCR were accepted or dismissed within the agency's own 20-day regulatory time frame. With respect to the 180-day deadline, some cases waited up to 10 years. More than 50% took more than a year for them to accept. Typically, outside litigation had to happen for the EPA to even move on the complaints, and overwhelmingly the complaints were denied. This is 2011. There was litigation, as you gathered, aimed at EPA's failed process during this time as well. There's a good case that comes out here. It's the Rosemere case in 2009 in the Ninth Circuit that essentially says that EPA's failure to process a Title VI complaint in accordance with its time lengths constituted agency action unlawfully withheld. This is really important because what it's saying is that the Administrative Procedures Act, which is another one of those, doesn't sound like an environmental statute, but we love it because it governs the way that government agencies have to work. They're saying that you can sue us when we fail to act under the APA, and specifically because we told you we processed these complaints in this timeline, this is a permissible use of the APA. So what about outside the government? What's happening with the legal tools? Well, as I hinted before, the Equal Protection Clause and Title VI of the Civil Rights Act, Section 601, are interpreted by the courts to require discriminatory intent. So it's not enough to show that the action that I took actually discriminated, that it had a discriminatory impact. I actually have to show that the whole reason I did it was because I wanted to discriminate against you. Well, life is not usually that black and white, right? And so the ability to have a showing of discriminatory intent is an incredibly high bar, and so we saw no cases successful on claims under those two that made it all the way through the court system. There were some early. Now 602 is a little bit of a mixed bag, because remember 602 said, and we direct you federal agencies to pass your own rules and regulations to show us how you're going to address these issues. Well, some of the agencies went with gusto, and they actually created regulations that kind of said, well, we can't discriminate in impact either. And so some early cases said, ooh, so you've kind of upped your authority here, and we're going to hold you accountable. So there was some progress on 602. The problem is that the courts never really agreed on whether or not 602 could actually do that, whether the agencies had the authority to go above and beyond what 601 specifically stated by looking at discriminatory impacts instead of just discriminatory intent. And this is still unsettled in the courts, so it's very unclear. But that's okay, they came at it a different way. What they decided was that even if on its face it looks like there's discrimination, you actually have to have something explicit in a substantive statute that says there is a comes along called Alexander v. Sandoval, which is about driver's licenses in the state of Alabama. Environmental, right? No. But that's typically how these things roll. It's about the Civil Rights Act. It's about whether or not the state of Alabama has to actually provide driver's license materials in multiple languages, and whether or not that's a deprivation under Title VI. We don't know the answer to that question, because the answer from the court is, who knows, but you can't sue us for it, because there's no private right of action explicitly addressed in Title VI of the Civil Rights Act. It says we can't discriminate, but it doesn't say if we do, you can sue us for it. So, in that dissent, I think Ms. Stevens says, but don't worry, 1983 says exactly that. It says you can sue when your civil rights are violated. So just make sure that when you say the law that's been violated, you also say 1983, and then you can get it there. But along comes Gonzaga v. Doe. Gonzaga v. Doe, another environmental case about Gonzaga in the state of Washington, and somebody who's upset that they didn't get into graduate school because of affirmative action policies. So that case then says, well, although the whole idea of Section 1983 is to give you a right to sue, you have to also have a substantive statute that showed that you have a right to sue in this given instance. And we can find nothing in the educational system or any of the statutes there that provide that right. So, yes, 1983 says you can sue, but it says you can sue only if Congress says you can sue somewhere else. So go find that provision, and then together you can tell us. So the entire provision of 1983 says you have a right to sue to enforce the Civil Rights Act, but only when Congress has told you you can sue for that specific reason in another law. So we no longer have 1983 either, after Gonzaga v. Doe. Looking at the dates of some of these things, you guys can imagine how fun my practice was. I came out of law school in 2000. I practiced for 12 years and then continued to do some practice while I was a professor. I also worked for environmental nonprofits before I went to law school for 6 years, between 1993 and 99. So looking at some of these dates, you should see some correlations. So what about legal tools? Well, all along there's been some reliance on non-EJ law and non-civil rights law in which we see some success in individual community environmental justice battles. Traditional environmental law, the alphabet soup that we talked about, works sometimes, right? Because what's happening here, to try and site a power plant. There's law that talks about what you have to do to site a power plant. Or they want to put this factory here. There's law that talks about what you have to do for that. Or they want to expand their factory and they now need a Title V permit under the Clean Air Act. So given the instance in your individual case, traditional environmental law can be a good legal tool to address a particular issue. We also have always seen consistently some level of torts. We talked about how the evolution of environmental law started with things like nuisance and trespass, right? That you interfered with the enjoyment of my property by what you were doing, or physically, if it comes on my property, you've trespassed, right? So torts have always played a role in addressing environmental justice issues. And we did start to see some additional advents of additional torts coming into play. And then in individual community battles, lawyers would get creative. They would find law that had nothing to do with environmental law or civil rights and figure out a way that it could apply in their given situation to make things happen. So sometimes this would literally mean that I'd go to the Florida legislature and I'd argue that they should give $200,000 to an environmental justice community because they were getting really polluted on and no one cared, but hey, could they at least have a health clinic, right? So you find creative things to address the consequences of environmental justice in the community. Believe it or not, there are siting of major manufacturing facilities that are stalled, not because they'll affect the poor black people in the community, but because a snail or a bird or a reptile is located on the site. Most of us environmental justice advocates love the bugs and buddies too, so we have no problem when the law will not protect the people utilizing endangered species law to achieve the same end. So with respect to traditional environmental law, as I said, there's been some level of success. I do want to talk about some of the challenges within traditional and not make that error again, right? So when you are trying to help a community, you want these legal victories, but you want the legal victories to be meaningful to what the community wants to do. Now, would we bring cases like that? Absolutely, right? Because they were real cases. They did something wrong, they needed to follow the law. And hey, when we make them go back to the drawing board, a lot of times they don't want to go all the way down that route. So they'll say, well, what do we need to do to get you to drop your lawsuit, right? So that we don't have to wait 3 years just to be told we have to do the rule again because we didn't have a public hearing, right? So yes, those remedies can have the consequences the community desires, but the law does not fashion a remedy that addresses a lot of those consequences, a lot of the times. I also like to talk about the square peg round hole, and this is legal services availability. So this too brings up an issue. I was an environmental justice attorney, right? So by most people's notion, that means that I live in court. If you know any attorneys, you know that some of them never go to court. They probably don't even know where the courthouse is, right? But on issues like this, you would think that we spend a lot of our time in court. And I absolutely did litigation. There's no doubt about it. But I also tried to figure out problem-solving approaches that avoided litigation for lots of different reasons, including some of the issues that we just talked about. But how many of you have heard of a group called Earth Justice? Earth Justice is the largest public interest law firm in the country. It started out as Sierra Club Legal Defense Fund. It was created as kind of an offshoot of Sierra Club. Some people know or don't know that, school diff. They changed their name to Earth Justice many years ago and it became clear that they were a separate entity. So they are attorneys that people hire to enforce public interest environmental laws. And so environmental groups, community-based, or big clubs like Sierra Club can hire them to be their attorneys. But like most nonprofits, right, they are dependent to their funders. And they're a public interest law firm. So if you go to a public interest law firm like Earth Justice, and you have a salient issue, but not one that necessarily can be solved through litigation, they can't take your case. Or let's say you do, but it's not in the umbrella of things that they're funded to work on, they can't take your case. So private attorneys have to come in and help with these situations. The good news is there's pro bono requirements. So we do get pro bono attorneys that sometimes get involved with these cases until they've done one and then we'll never do that again, right? We also have nonprofit environmental organizations that are like, oh, our members live in that community. We're also concerned about that. So we're going to take our own attorneys that are in-house. Sierra Club has their own Natural Resource Defense Council, many others have their own. And we're going to fight on their behalf. But then there can be an issue of competing client interests. Because what you're willing to accept for the coal plant, when you're anti-coal plant, is one thing, but what you're willing to accept from the coal plant when it's going to be across your street is a different thing. And the lawyer can't represent people with competing interests at the point that they start competing. So sometimes you find lawyers to take the case, but the big groups are the ones paying the bill, right? And it's all fine and dandy why things are going the same direction, but when the rubber hits the road, the lawyer finds themselves in an ethical dilemma. Work for the little guy and don't get paid, work for the big guy and try to get a solution, right? So one of the things that I want to draw to your attention is that within the legal system itself, we have a lot of impediments to lawyers being able to help people with these types of issues. And so that in and of itself is also a problem with being able to access the use of traditional environmental law. And when you get private attorneys involved sometimes, it sounds like it's a cut and dry case, but they start seeing that alphabet soup, and like I said, they'll never take another one of these cases, right? Because it is an incredibly complicated area of law, and nobody learns all of the environmental statutes, even in law school, even if you specialize in environmental law. You learn how to read the law, and every case you have, you learn a little bit more about one of the laws. But it's a huge learning curve, and so trying to find people that can actually handle those cases is incredibly difficult. So during this decade, we also see the contract for America. You might notice that I changed the proposition here as on. The contract on America was the way that the environmental community whether my client did anything wrong, Your Honor, we'd like to ask whether or not they have a right to challenge, even ask us whether we did that right thing and whether you can even decide that. And so we spend lots of time and money on these types of jurisprudential doctrines. Well, at the advent of the environmental movement, when citizen suits, which are in many of those traditional environmental laws, started being invoked, there was kind of this general philosophy that you could pass standing if you were an environmental group, because your purpose was to address the issues that the law was specifically to address. And so standing didn't seem very hard to prove many of the times. But then we saw a couple of cases. They are Lujan versus Defenders of Wildlife and Lujan versus one of the other groups, I think the Federal Wildlife Federation, because Lujan liked to sue people. He was the secretary of the government. My students are always like, I'm like, who's Lujan? They're like, I don't know. He really sues people. I'm like, no, he's the secretary of the agency. So you start to see these same names cropping up in the cases. That's when you know that they're probably a government entity. So anyway, Lujan brings several cases against the endangered species, attacks standing against environmental groups under the Endangered Species Acts in several cases. Early cases, like I said, standing kind of sailed through. But all of a sudden, in Lujan versus Defenders of Wildlife, the court holds that the plaintiffs can't challenge the federal agency's ruling regarding the Endangered Species Act, even though they have members who have an interest in the endangered species, who have seen it before, one who's a biologist who studies it, because they couldn't show that they intended to travel abroad to see the snow leopard anytime soon. And so they started saying that they didn't have an immediate enough injury in order to bring a citizen suit under the Endangered Species Act. Now I'm simplifying things, but this is the general gist of it. So we start to see a sign that the courts are going to get more strict on standing texts in the context of environmental law. Many people come out of that feeling generally okay. We still see citizen suits under other laws moving ahead fairly well. But in 1998, they then attacked the third prong of the standing doctrine. It's got three things you gotta prove, which is redressability, which is even if you have that injury, even if that injury is immediate enough, can I, the court, do something that's gonna make it better for you? That's what redressability is. So the Steele County case is Steele County versus Citizens for a Better Environment, which is an environmental group. And in this, it's an epic case, right? So you all know one of my favorites, the Emergency Planning Community Right to Know Act. Because Steele Company didn't file reports that they were required to file. And so they continually asked them to file the reports. The government did not ask them to file the reports or didn't care whether they were filing the reports. So the citizens brought it to court to say they have to file the reports, and if they don't, then the government should take enforcement action against them. And while the case was pending, they went and filed the reports. So the new order of business became, we don't do something until someone sues us. Because the court then said, oh, they filed the reports now, you have no redressability. So the case is dismissed. So all of that time and money that you spent, and your nonprofit attorney who was going, at least I'll get attorney's fees, no longer, right? Because now the case is moot because they have finally filed the reports. But ask yourselves, is it supposed to work that way? Is it supposed to be that we only do what the law requires if someone sues us, and at that 23rd hour, we'll comply? So this starts to be an issue here in the context. You know what, I'm confusing two cases. Hold that thought, because that comes into the catalyst theory in just a minute. In Steele Company, specifically, just so that you guys know, in that instance, what they said is that the penalties by the government wouldn't go to the people bringing the suit. They would go into the federal coffers. And therefore, it didn't redress their harm. But they said, well, sure it does, because we want them to be enforced and do the right thing. But that wasn't enough for redressability. So I confused Steele Company for a minute with Buchanan, which is a home health care case. It's involving nursing homes in West Virginia. So that one is even worse, because this whole concept of we'll finally do the right thing, in that concept, they actually have the legislature change the law in the middle of the court case. And the law says that you can't have your attorney's fees, because even though they proved that they had done something wrong, The catalyst theory is you get attorney's fees if the case you brought was the catalyst for compliance. But they didn't get to that point because the legislature just changed the law so they know we're no longer out of compliance, even though they were out of compliance at the time that the act happened. And the court said that wasn't an example of the catalyst theory because you didn't win in court because the law was changed before we got there. So all of a sudden, the nonprofit groups that do rely on these attorney's fees because their nonprofit clients or their community-based clients can't usually afford to pay, no longer have guaranteed wins with attorney's fees provisions because you look at what happens in these couple of cases and you show direct assault on attorney's fee provisions as a way to usurp citizen suit provisions. So what about torts? So as we talked about before, we saw use of nuisance and trespass. We also started seeing cases on negligence theories and sometimes strict liability on some contaminated sites or hazardous handling statutes, personal injury, wrongful death, diminution in property values, and medical monitoring. These are all different toxic torts that have been used in environmental justice communities to a certain level of success. But just like the environmental law, there have also been some challenges and limitations to this. So first, most of the torts are done based on a contingency fee. The attorney agrees to take the case because if they win, they'll get paid. Okay? So separate from the citizen suit provisions and attorney fees provisions that come with traditional environmental law, in standard tort law, under tort theories, there is often an ability to recoup attorney's fees by the prevailing party. So that's what we're talking about. So a contingency fee arrangement came about sometime recognizing that this was the only way that some people could afford to have attorneys. And so they get paid only if they win. And in theory, it's a great concept. And sometimes it really does work, and I've seen it work. But you have to figure that people, attorneys, before they take the cases, are doing the math, right? Because I don't always win. And how sure do I have to be that I'm going to win before I agree to take this case? Because I might get paid nothing. And I have a right to get my expenses, but I have a lot of times clients who can't pay the expenses. So I might not just get paid an attorney fee, but I might have spent all this money on the case that I also don't get paid back as well. So just know that in order to feed their children, right, and put a roof over their house, this is how tort attorneys get paid. And so it makes sense that they have to do the math to determine whether the case is viable being taken, which means that a lot of times only the slam dunk ones get taken. But let's also be clear, it's not just when there's a clear problem, it's the ones that can bring in enough money. So that means it has to be something that affects a lot of people. Because if I'm Tallavast with 85 homes, my dollar value for that case is not the same as in Love Canal where there were many, many, many more homes, right? So your small community has an access to legal services issue associated just within the tort structure. That also changes the type of torts that they'll bring. So property value diminution is relatively easy to prove once someone has proved that their contamination got on my client's property. It's much harder to prove that their X molecule of TCE that went in my drinking water, that was used in my baby's bottle, then led to leukemia, right? Because you've all seen a civil action, right? So in Woburn, Massachusetts, there are all these kids that are dying. There's a cluster of leukemia, and they're deposing the parents and saying, yes, we know your child died or is dying of leukemia, but let me ask you, has he ever eaten peanut butter? Do you give him sugarless gum? All other things that have possible carcinogens are brought into the mix. So now we're spending money, dollar after dollar, to prove that X molecule caused X cancer, right? And meanwhile, people are dying. So your ability to bring wrongful death and personal injury cases on these theories of negligence are very, very difficult. The other thing to remember is that just like with traditional environmental law, you have some remedies issues as well. Medical monitoring sounds awesome, right? And any community who thinks they have health consequences from their exposure wants medical monitoring. But medical monitoring is not the same as health services. So we'll talk about Pensacola and how the people living near Mount Dioxin got medical monitoring. So you know what they got to do? They got their blood drawn and they say, yep, you have unusual levels of X, Y, and Z. Good luck with that. But we have a $3 million pot of medical monitoring that we want in court. Yes, ma'am, but that's only to test you to determine if you have actually had exposure. So, just like traditional environmental law, some of the tort actions also have limitations and remedies that the court can fashion. So, Love Canal got a trust fund. Is that because they found some loophole? No, they settled out of court, right? So sometimes we bring cases and hope that we can get things out of court by settling that we know we can't get in court because the remedies are limited. There's also the divide the pot phenomenon. How many of you seen those things that are like Mount Dioxin gets $3.3 million in medical monitoring and I don't know, it was some even larger number in the $30 million for property diminution of value. Anybody seen any of those toxic tort headlines? And the average person's instinct is awesome for them. But there are thousands of plaintiffs involved. And first they're taking out all the costs that they had to prove the chain of molecules. And then they're taking out the attorney's fees, which is good, we got the attorneys, but they're there because they get somewhere between 30 and 40% in most instances, right? So we're talking about tens of millions of dollars that end up resulting in like a couple $100 in each person's pocket. But the community, the populist perspective is, those people make out. I'm telling you, they never make out. That's the divide the pot consequence. So we also talked about creative tools. I already told you some examples of how we use this. We'll talk about it. This is still an issue, and any attorney who can get involved should try to think creatively about addressing each case-by-case issue. So then we go to the Obama administration. We have a renewed interest in the federal executive government role. Just some foreshadowing, it's still depressing. Okay. So the Obama administration does a ton on environmental justice. We're coming up to the 20th anniversary of the executive order, so it's fueled. It's our first African-American president, right? Environmental justice is going to be a priority. So, and it is. They start by reconvening that interagency working group that we talked about that started under Clinton. It was the first time it met since 2010. They had EPA's strategic plan for 2011 to 2015, which included environmental justice goals specifically in it. There was a White House forum in December of 2011 where they invited community advocates and environmental justice attorneys to the White House to dialogue on how the government could do better. They established an EPA work group on civil rights to figure out why the Title VI process wasn't working. And in August of 2011, 15 agencies signed memorandums of understanding saying that they're going to actually do what the executive order told them to now, and each year they'll tell you what they did. So a lot of this ends up culminating in what was known as EPA's Plan EJ 2014. It was issued in September 2011, and it was a 4-year strategy to help integrate environmental justice into EPA's day-to-day activities. It had 3 goals, which seem like anything an environmental justice community could ever want. It also identified 3 primary areas: cross-agency focus, tools development, and program initiatives. And for all of these, it actually had implementation plans about how they were going to achieve the goals within these different things. Now, civil rights was identified as a priority, but it was indicated that it would be handled separately. And so it was never included in the primary report, it was its own report. So I have a whole law review article that I became a detective to figure out what happened with Plan EJ 2014, because although it was supposed to have annual reports and culminate in a final report, It didn't happen or get published on the EPA website until just recently. And it was supposed to culminate in 2014. I know it seems weird that it's come out all of a sudden, but it has. So I had to go through all of the agency memos to try to figure out what actually happened with Plan EJ 2014. And the good news is there were some positives. See pros. So there was education across government, meaning that federal agencies across the board were actually taught what environmental justice meant. And they were taught about how to see if it plays a role in what you're doing. It became integrated into regular policy conversations within the agencies, and as we all know, education is always the first step. So these were huge. And they identified areas where there were EJ opportunities might present themselves. The cons. This massive undertaking that took 4 years resulted in the passing of no law. It was a strategy. It was not a rule, it was not legislation, it was not executive order, it didn't become statute, it was just a strategy. So why is that problematic? Well, one, that lacks permanence. We know that laws lack permanence, because I already told you they make them, they repeal them, right? They put them back, they tweak them, etc., etc. But law is much more permanence than underlying rhetoric and policy within the agency. So without law, someone doesn't have to publicly take it away. The conversations can just stop happening when you have an office of 12 people that all of a sudden only has 2, right? So the failure to give any permanence to these great things that they did means that their ability to continue to change the way the agency approaches environmental justice is lacking. Also, because there's no law, we still have no private right of action. So essentially, even if you finally get people taking their duties responsibly, when they don't, you can't sue them to say they didn't do it because that doesn't exist. So, kind of the bird's eye view during the Obama administration is that multiple things happened that I think kept Plan EJ 2014 from being as successful as it could. To be clear, there never seemed to be a commitment to pass law. And so that was likely going to be a consequence of Plan EJ 2014 regardless. But several things happened. Lisa Jackson, who was the first administrator under Obama, who had personal priorities with environmental justice, left during the middle of the Obama administration. And so after she left, like I said, I couldn't find annual reports and other things like this. Climate change took over. So just so we're all clear, I love bugs and buddies. I also like climate change. I believe climate change exists. I'm not saying climate change is bad, so please don't take that to mean this. What I'm telling you is that if you remember, Obama did a bunch of stuff on climate change a couple of years into his administration because it became the hot button environmental issue. And truthfully, environmental justice goes hand in hand with climate change because those who suffer greater exposure to pollution also have greater health consequences. And those with less socioeconomic means and less access to care also are those at greatest risk from climate change. So it made sense to use it to advance the environmental justice platform, but by many accounts, it kind of got lost in the mix. And as I said, there was little to no reporting on what was actually happening in the agencies, so it was hard to hold them accountable. So where are we now? In the executive branch under the Trump administration, there's nothing directly addressing environmental justice, although there has been a dismantling of some of the climate change policies that Obama, which do have, as I said, an effect on environmental justice. EPA, in the end of the Obama administration, they attempted to wrap Plan EJ 2014 into the 2020 action agenda, which was to set the strategic plan for EPA for the first years of the Trump administration by the Obama administration. So they tried to shove Plan EJ 2014 down the Trump administration's throat. To some degree, they actually have been successful. I only recently figured it out, though, because in the first few years of the Trump administration, I call it hide the ball, when I tried to assess what was happening with Plan EJ 2014 and the 2020 agenda. And now it's best foot forward. Best foot forward is an improvement, you guys. So the hide the ball, if you looked on any government agency pages when the Trump administration first took ownership. This is why some of these reports I now know exist, but I did not know for years that they existed because they didn't exist anywhere out there in the public. So it was really hard to tell what Obama had accomplished at the end. It was also hard to tell what Trump was still doing or not doing during the early years of his presidency. But now it's best foot forward because we're in campaign mode. So the good news is that they've continued to do a lot of the good things that Obama did start. There still seem to be conversations, even if they're only happening between 2 instead of 12 people because EPA's resources have been slashed. But environmental justice is not a huge priority to President Trump. And that's okay, because it means it's not a target for dismantling like some other things are. I'm being honest with you guys. I genuinely feel positive to have found that they're still doing these things. There is an annual report on environmental justice for EPA for the last 10 years on the website. It was not there last year, because I taught a course on environmental justice and I made my students go look for it because I couldn't find it. Because they weren't there. That's what I meant the first 2 years where I had the ball. Now let's put your best foot forward. So now we are touting that these conversations are still occurring, that the education is still there, that there are people now better informed to look at these things. But because the Obama administration never bothered to pass law, and because the Trump administration is not going to pass law, we are still in that education perspective. So what about the Title VI grievance process? In 2015, there was a report from the Center for Public Integrity, and in 2016, there was a report by the U.S. Commission on Civil Rights that it basically said they're still doing bad. There was another victory in court in 2018, this is Californians versus Renewable Energy, that again said, hey, by the way, EPA, your rules say you have to do this in a certain time frame, you are failing to act under the APA. Why are we having that case that looks exactly like Rosemere? It's because right now we're challenging all legal precedents to see if the court has changed their mind. So where we will end up on this is anyone's guess. So the last few minutes, I just want to talk to you about Florida. So you should know there have been a couple of creative laws in Florida that help address these issues. The Brownfields program, Florida charted territory on Brownfields programs, which has helped with EJ communities. We also had a community environmental health program advisory board, but it fell to the wayside during the Scott administration, but the statute still exists. FAMU was also given a Center for Environmental Equity and Justice, and it continues to do outreach with communities. Remember that the role of states is really important, and some states have passed their own environmental justice legislation. My university, where I got my law degree, the University of California, Hastings, does a report on states' response to environmental justice. Florida falls kind of in the middle. There are states that have done a lot, there are very few. There are most states that have done nothing, but some of the things we just looked at in the last slide make Florida kind of in between. Also remember though that while most environmental law is federal, it's delegated to the states to carry out. And so without a lack of any environmental justice law in the state of Florida, as well as none at the federal level, the state agencies are able to carry out environmental programs without much consequence to looking at environmental justice. So briefly, Pensacola, I already introduced this to you. This is a community that has a significant number of contaminated sites, historic African community in Pensacola. There actually was federal relocation for the community outside of this plume into another part of the plume they came to find out later. So in many circles, this is considered an environmental justice success because they were able to remove the people from ground zero, but as they came to better understand the extent of the contamination, they found that many people had relocated still within the footprint of the plume. At that point, though, they were saying there was no ongoing exposure, and so people weren't at greater risk for it. It also had a tarp on it that was supposed to last 10 years that has been on it for decades, and you know Pensacola never gets hit by hurricanes. Another case that I worked on is actually in the Glades. There are some small towns called Pahokee and South Bay, another small town that's a little bigger called Belglade. They all sit on Lake Okeechobee. Many of you are concerned about the issues associated with Lake Okeechobee, and most people are concerned about Lake Okeechobee from a boating, fishing, once upon a time swimming perspective. But imagine if your drinking water came from it. Because these three communities drew their drinking water And we found significant problems in the early 2000s of something called total trihalomethanes. There are 4 of them. They are all probable human carcinogens. And the Safe Drinking Water Act protects you in this large city of Venice, but in Belt Lake, Pahokee, and South Bay, they were not required to meet the standard. I used to say it's because if you live in a small town, you are less able to catch cancer from carcinogens. Not sure. But the law allows those small towns, because of economic reasons, to not have as protective standards from things that we know are carcinogens. So ultimately, this case resulted in the development of a regional water treatment facility. And in this instance, we got EPA involved, and for the first time ever, they brought bottled water into communities in a non-natural disaster context. We redefine victory in these cases. But this is a great case. Northwest Ocala, the Royal Oak Charcoal Factory, was closed down after years of violating the Clean Air Act. When I first got involved with the case, I talked to someone in the state of Missouri where most charcoal factories are, and they kept saying something to me about whether or not the plant had an afterburner. I don't have a science degree, right? And he explained to me that what I was telling him I was seeing and the community was experiencing was not possible if you had an afterburner in place. So I got the permit, and I found the afterburner. So I thought. But after years of putting pressure on the agencies, DEP finally decided to do an inspection without calling the plant and telling them they were coming first. And not only would they call and tell them they were coming, they would take the plant manager to the house of the citizen that complained so that they could meet each other and Royal Oak could tell them what a great job they were doing for their community. And I asked them to look for their afterburner. There was and never was an afterburner. But the permit was predicated on an afterburner. And it was okay and not detected because opacity was okay. But the way that they determined opacity was there was a guy who had a little certificate on his wall who would go upside and look at the sky and go, looks about 10%. And he'd write it on the report and he'd send it to the government agencies and they'd find them in compliance. Because that's all the law required. He would do this at nighttime because they would amp up production at 2 o'clock in the morning. These are the things that happen in environmental justice communities. So we did a huge campaign to educate people about what was happening on Royal Oak, which ultimately resulted in the plant closing. We don't always advocate for that, but in this instance, it made sense. But I will tell you that part of that was empowering the community. Several of the communities I worked with became part of the National Bucket Brigade Coalition, and they started doing their own testing. So instead of going to City Commission and saying, our air smells funny, they would come in and they would show sheets that they left out to dry that were covered with soot because this is what it was like living next to Royal Oak. And then they would show lab results of air testing that we had taught the community to do using a 5-gallon bucket and an insulated lung approved by EPA. But it took that conversation to get anybody involved in this community. And then there's Tallavast. Tallavast, as you can see from the picture with the fence, looks like a really, really scary industrial facility, right? No. It looks like a warehouse. Unlike Royal Oak, where the first time I went there at 2 o'clock in the morning, I knew from tens of miles away where I was going. In Tallavast, I had to walk through and I had to drive through and drive back through before I could figure out what a plant site was. It looked like nothing more than a warehouse. But they machined parts for nuclear weapons. Now, luckily, as far as we know, there are no nuclear issues there. But there were industrial solvent issues that created a plume in the community. The way the community found out that there was a plume in their community was one day, a woman that I call the matriarch of the community, Laura Ward, was pulling into her driveway and she saw men installing a well. And she stopped and said to them, what are you doing? And they said, I'm installing a well. She says, no, I already have one of those. They said, oh, it's not a drinking water well. And she said, well, what kind of well is it? They said, it's a monitoring well. Well, why do I need a monitoring well? That's my property. And they said, you know, it's because of the contamination. And then their buddy elbowed him and they stopped talking. And that's how the community found out that their community was contaminated in Tallavast. So they then started requesting information from the government agencies. And they found out that Lockheed Martin was taking responsibility for the cleanup. They had identified a plume of 5 contained inside, that there was no current routes of exposure to anyone in the community, and that the cleanup should only take a few years. They also identified that nobody in the community was on well water. Half the community was still drinking well water. No one in the community was on public water before 1984. And this is early 2000s. And they documented releases at the site as early as the 50s. So the community got involved, and ultimately the plume was determined to be more than 200 plus acres. It was determined that it would take 50 to 100 years to clean up. 4 industrial solvents are found in there, some thousands of times the limit of what is acceptable to be exposed to. This is a historic African community that was found by freed slaves and prior migrant workers. Almost everyone in the community was related to 5 families. They had 2 churches in the community. The patriarch of the community ran a dental practice in the community in the evenings for people there in the nearby surrounding areas. And it took them getting involved for 5 years to get DEP to acknowledge that the contamination was as bad as it is. We're now 5 years into the cleanup, and despite the state approving the cleanup plan, they're now saying that it is not working the way that they expected it to. So the community is expected to continue to deal with the contamination cleanup for the rest of their life. What are the lessons learned in environmental justice community? No one size fits all. You must use multi-pronged strategies. Litigation or legislation is not just going to work. The community has to drive that strategy, and there are systemic impediments to legal solutions. What more could be done? Legally, we need environmental justice legislation at either the federal and or state level. We need a new executive order or an amendment to the one that exists, and we need federal executive agencies to utilize the full powers that they have under environmental law. We also need to do more about educating people, creating more broad alliances, and increasing community empowerment on these issues. This last slide I won't run through, but I'll leave sitting up here while we do questions. But all of these decisions are typical in the environmental context. If you're involved in any situation where one of these decisions is making, there is a decent chance that environmental justice concerns might be present. So these are how you can figure out whether or not you need to ask questions about those impacted. Thank you.
Ms. Paben, I would like to say thank you for all the information that you have brought to us and all the thoughts that you are leaving us with.
Thank you.
You have imparted so much information that when I look at the clock, we have 3 minutes for questions. Is there anyone that has one burning question? The reason is that we have to clear the building. So it's not that we're trying to put limits on what you can ask or when, but we have a very short period of time. So is there one question or so? There's a microphone over there, there's a microphone over here.
I'm happy to talk to people outside and also provide my contact information. There was some confusion on the timing, so I apologize for not having more time for questions.
Please don't apologize. You've given us a lot of information, and thank you so much. And you heard her. Go to the microphone, please. This is so that we can hear, everyone can hear the question at the same time.
I just want to let people know that I have information based on last week's talk about Amendment 4 and returning rights to people with felons. It's on the table back there. Thank you.
You mentioned climate change, and I just want to say something very quickly. There are several bills in Congress addressing that and trying to reduce our use of carbon fuels. I'm sure you're aware. And there's 2 particular. There's a new Green Deal, and there's another one that is called the Energy Innovation and Carbon Dividend Act. And both of those kind of complement each other. And the Citizens Climate Lobby is one of the major people working on this, if you're aware of that. We have a chapter here, the Citizens Climate Lobby, and we're going to have a meeting this Friday at 10:30 at the Unitarian Church up at the intersection of Manatee and Edmondson Road. So we'll be talking about that. And I see Bob Price is back here, still here. He has some very interesting ideas about some phenomenology